Welcome back. We are still covering the case out of Ohio where Skylar Richardson is being accused of killing her recently born child 2 days after her prom. Now, the court is currently on break during lunch, but here at the Law&Crime Trial Network, we don't take any breaks. So we're going to continue with some of the testimony we heard earlier in this trial, specifically going to Skylar Richardson's police interview that we had seen. Let's take a look. Now, I'm joined here by Jose Nieves in studio, and I still have Joseph Tully via Skype. Jose, how you doing today?
Good, how you doing?
Good, always a pleasure to have you here.
Thank you.
Now, former prosecutor, now you're on the defense side. Like I joked before you got on, welcome to the dark side. It's a lot more fun on this side. We've got this quite interesting case, and I kind of like the conversation that we were having before we jumped on. I kind of want to carry that on for a bit. It's interesting how this case got brought up, where the facts are, or the issue at hand is, did she murder this child? But there's all these kind of ancillary and all these other kind of concept of abortions and a young girl having a baby and all this. A lot of things we're talking about is kind of a side note to the murder. Do you think this is a case where maybe not the ultimate issue is going to decide, but a little bit of X and Y and Z is going to be what's going to decide this case?
Yeah, especially when you're dealing with jurors who are coming from very conservative backgrounds. Maybe they live in a community that has very conservative values. They'll make judgments based on their values. You know, jurors are often told not to take those things in consideration, to leave that aside, but they're not to leave aside their common sense. And if their common sense says that a person, you know, story doesn't make sense, and if the facts don't support their defense, you have to convict. And their values usually bleed into whether they find the defense credible or not. You know, and I think that's where it really becomes other things that dictate the outcome of the case, other than the facts.
Yeah, and Joseph, let's get you in on this as well. I often tell my friends, family, fiance, whoever it is, sometimes cases like this are won in jury selection. I mean, I think you can have this case done 10 times with 10 different juries and maybe get 2 or 3 different verdicts between guilty and not guilty and hung. How important is jury selection in a case like this when, as Jose noted, sometimes there's a bit of a conservative aspect as to how this should have been handled?
Well, as Jerry Spence, who is a great defense attorney, used to say, jury selection is everything. It's not only important in this case, it's in every case. To a lot of people, picking a jury is a very, very boring process. But to a lot of very good attorneys that I know, watching voir dire and doing voir dire and being good at it is key to doing what we do.
Yeah, and also to your point, I want to echo this again, and I can't echo it enough, Joseph. It's also about garnering credibility from the jury towards the defense attorney, because that's on one side I'm always on. You want to be the person in that room, whether you're a prosecutor or defense attorney, and say, hey, look to me for the answers. Look to me for credibility. Let's go back into some of the testimony that we saw in the form of the police interrogation, where the defendant was being asked questions by the detective. So a very curious interrogation there. You're seeing some parts. I know yesterday we had Mike Korobonics, or Korobonics as we're calling him now, talked about the read technique. And Jose, we were talking about how even in your past life as a prosecutor, you're saying that you guys hate this when a detective kind of feeds a defendant the information, because what does that do for the prosecution's case?
You know, I think it always calls into question the voluntariness of the statement, whether the statement is based on the knowledge of the defendant, or is them trying to adopt what the detective is saying to them. And I think that's why it's a better course of action to bring in a prosecutor early on in the stage to do the questioning, because we see how these issues come up at trial, and we'll try to prevent them. And when detectives, they become very zealous about trying to get a statement, and they may leave certain impressions, like you're going home after the statement, or we're just trying to find out what happened and then you can move on. And those are not things that you should be doing, especially with a minor. A minor that may have less IQ or lower mental capacity than an adult, you don't want to put them in that situation. I think courts have said repeatedly, you have to look at the defendant's age, mental capacity, their understanding of the language. These are real important things when you're taking a statement. Yeah,
she was very young. I think at the time she was like 18 and like 4 months.
Right.
So I know, like, legally speaking, she's not a minor, but I think in terms of a mindset, when I hate to say it because I'm only a few years out from there, but I think the brain doesn't fully develop until you're like 27, 28. And so, and to your point, like they're not fully developed, even though the law would say, hey, you can vote, you can serve your country, you can do all this. Joseph, to you, when we're talking about questioning someone and not filling in the blanks for them, I think earlier the defense did a really good job of when the officer, or the detective, sorry, was trying to give her information. It was like, oh, did you burn the body? And I think it came out, she said, oh, I held a lighter to the baby and the baby caught fire. Now in court, you can say, well, that's ludicrous. I mean, a baby's body is 80% water. That's not going to happen. There are no burn marks in the forensic pathologist. So now we know that she's being fed information that's false. And now you can kind of do a falsus in uno, falsus in omnibus, where it's like, if one thing is false, then all of this must be false. I mean, that's only, sorry for the pun, that's fuel for fire for the defense, right?
It is, although, you know, well, number one, what I heard in this video right there is her saying, do I still get to go home? Almost pleading with the officer to go home. So the defense can use that to establish that, yeah, he was feeding her information on one hand, and on the other hand, she wanted to go home. She was vulnerable and was willing to give the officer everything that she thought that they wanted. For instance, the example you gave about lighting the baby on fire, which would be ludicrous.
Yeah, it's very interesting, and I would have loved to have been a fly on the wall during the suppression of this statement, because it doesn't sound quite voluntary to me. It seems like it's a carrot and a stick. It's like, hey, I'll give you whatever you want so long as I can get home. It doesn't seem voluntary to me. But very interesting. That last part there, I think it sparked a lot of questions here in the studio and both with our guests via Skype. I want to jump in and ask Judge Ashley Willcott, who's joining us now, the first question. First, how are you doing today, Your Honor?
Good, thank you. Thanks for having me, Brian.
Always a pleasure. So, Jose and I were talking about this in studio, but I want to pose a question to you. She's Googling how to get rid of a baby. And I know that in the past, the prosecution brought up in the opening statement, they kind of hammered through it during the case, and I'm expecting them to do it the same thing on closing arguments. But in my mind, I think all four of us maybe have experienced this, where you tell a client, you tell someone legal advice, and the first thing they do is they Google it to be like, nah, I disagree with you. And I think it's pretty common for people to do the same thing with doctors, where a doctor tells you one thing, you're like, I don't know. Maybe Google will give me a better answer. So is there maybe a benign reason for this, other than the malicious one that the prosecution's trying to give us?
Well, I think there could be, and I think the defense has to argue that to this jury. And so, Brian, the thing I'm going to remind everybody is teenagers their brains are not fully developed. You pointed out she's almost 18, but they're also not fully developed at 18, their brains. And so they make stupid decisions, do stupid things. All teenagers do. Now, this is egregious. Don't misunderstand me. But I think the defense needs to capitalize on things like that. The other thing I have to say that you all mentioned a little bit earlier is she isn't even 18. This interrogation bothers me because of the rights of juveniles being minors, the brain development issue. And I just feel like, in asking these questions, they're really trying to get her to trust them. And I just don't feel good about this interrogation in terms of her rights being protected. Yeah,
and I think just for clarification, I think that she is recently 18. I think she was 18 in like a few months. And so in terms of it's, the law would say, yes, you can definitely ask that question, but I think that the science hasn't caught up to the law as yet. I mean, maybe I'm the closest to 18 here. I mean, my brain is just fully developed. I'm surprised they let me do this job sometimes, but there's no magic switch. I mean, Joseph, you don't go from 17 and 364 days to 18 and all of a sudden your brain just fully functions. I mean, these questions about the Googling, we can tell where he's trying to go with this, he being the detective. I mean, where is the prosecution going to interject and say, hey, this is where I can show you intent. This is where I can show you malice of forethought as to the murder. How are they going to twist this or use this to get their goal?
A rule of thumb, I'm not saying this is the case in every situation or the case at all, but as a defense attorney, what you have to be prepared for is the worst evidence coming in. I prepare for trial with 2 rules of evidence. If there's something that's bad for the defense, it's going to come in. If there's something that's good for the defense, it's going to stay out. And again, that's me being a little bit pessimistic. But if you prepare for a trial in that manner, you'll be covered. So to your point of what is the prosecution going to use, they're going to use this whole video. The prosecution needs to slander the defendant and make the jury think she's a bad person. If she's a bad person, she deserves to be convicted.
So, Jose, I'll pose this to you. When I was in law school, I was told when it comes to an argument, you can do one of three things. You can ignore it, you can face it head on, or you can twist it to work for you. So when you look at this video, what do you think might be the best way to combat it as a defense attorney? Ignore, head on, or twist?
I think the best thing is to twist it. I think you don't ignore a statement. It's going to be out there, and you want the jurors to look at it in a certain perspective, and the eyes of a young person who's scared, who thinks they're going home, who's being given these facts, and from the prosecutor's perspective, you want to show the jury that she knew exactly what she was doing. She was researching this, she was carrying out a plan, and she's an honor student, so this is the type of research that she would normally do to try to figure out a problem. She had a problem, and her problem was that she was pregnant, and she was going to solve that problem the way she wanted to, without anybody knowing about it. And then this was, unfortunately, the course of action she chose.
Yeah, as you say, the facts are always the facts, but how you present them is definitely the way that either side is going to win the day. And before we get to the winning of the day, though, we got to take a quick break, and we're going to have more with Ohio v. Richardson.